بسم الله الرحمن الرحيم الحمد لله رب العالمين وأفضل الصلاة وأتم التسليم على سيدنا ونبينا محمد وعلى آله وأصحابه وأتباعه إلى يوم الدين. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا رشدنا يا رب العالمين. Alhamdulillah. In our lessons on the Mukhtasar of Imam al-Quduri rahimahullah ta'ala, in the section on transactions, we have completed looking at the rulings related to the mudarib, correct? Right. The issue of working capital. And we reached Wakala, right? Right? And Wakala, agency, is, one of the important chapters. One, intrinsically, in of itself, it's important, but it's also important because an employee, for example, acts as a wakil, as an agent on behalf of their employer, right? And many other situations, partners in a company are acting as agents on behalf of each other, right? So it has wider applications as well. So that's one thing to keep in mind. The other thing to keep in mind with respect to wakala, is that wakala is min tasarrufat al-amana. Right? The wakil is mu'taman, right? Is being trusted. So that has all the implications of trusts. Only take on a trust if you can, in fact, fulfill it. Right? So Kitab al-Wakala, right? In the Arabic language, so the commentator tells us in the Lubab that wakala in the Arabic language is from tawkil, which is to make tafweed, to consign a matter to another. Fawwada yufawwidu tafweedan. It has the sense of activeness, is to consign a matter to another. Right? And the commentator, Alam al-Maydani, says that the Shar'i meaning is إقامة الغير مقام نفسه في تصرف معلوم. It is appointing another in one's place in a particular act. Yeah? In a particular act. And he quotes Al-Jawhar al-Nayyara for that. Its integral is ijab and qabul, right? If you see item 1451 of the Majalla, he mentions that, right? Okay. So it's appointing another to act on one's behalf. The basis of wakala, of agency, is that it be general, right? That one's an agent in everything. The basis of agency is that it can be either general, but that's rare, right? That, okay, you have complete authority to act on my behalf in everything. It's normally of the second kind, which is muqayyada. And there's levels of specification, right? It can be as specific as, one transaction, right? That I have a copy of a book, I say, can you sell this on my behalf? Right? So it can be as specific as, as that, or it can be in a type of activity. So for example, if you hire an employee, as a sales agent. They're selling on your behalf. But do they have they don't have a right though to act outside of the bounds of their employment. So they're a wakil within the bounds of their employment, not outside of that. Imagine if the store manager decided to sell the company to somebody else. Right? The store manager is a wakil at the, so if you just imagine in a company, like imagine a supermarket, the person at the cash is selling on behalf of the company, so they're a wakil. But can they make purchases on behalf of the company? No. But the manager has broader wakala. The manager, of one particular store may be able to hire, may be able to fire, may have some purchase decisions, but not others, right? So the wakala, the critical thing in it is that there be taradi, clear mutual agreement about the scope of the agency, what one can do on behalf of the other or not, right? So those are some foundational principles. The author begins, Imam al-Quduri begins, rahimahullah ta'ala, with a governing principle with respect to agency. So he tells us, كل عقد جاز أي صح أن يعقده الإنسان بنفسه جاز أن يوكل به غيره. That every transaction, every contract that is valid for a person to effect on their own behalf, it is valid for them to appoint another as an agent to discharge on one's behalf. And the wisdom of its legislation is obvious, because a person goes under the broad principle, خُلِقَ الْإِنسَانُ ضَعِيفًا. The human being's been created weak, right? We have needs. Not every need can one fulfill oneself. Sometimes there are, one has more things to do than they can do themselves. So they need to work with others. How does the other person work on one's behalf? You give them agency to act on your behalf. Someone may be more adept at something than yourself, right? So there are many levels of need that are lifted by it. Right? But ويجوز التوكيل بالخصومة. One can appoint an agent to be the one making the claim on one's behalf in all rights. And that's what a lawyer is. A lawyer, that's why in many cultures they call the lawyer a wakil. Right, so I want to make a case against somebody who spilled tea all over my carpet. So, but I don't want to take them to court because I'm busy. So what do? I appoint Hafiz Zain to be my wakil bil khusuma. So they go and make the claim on my behalf, right? In all rights. Wa bi ithbatiha. In establishing a right, right? Right? And there's some detail in this. You can see that. وَيَجُوزُ التَّوْكِيلُ بِالِاسْتِفَاءِ. And it is also permitted to appoint a wakil in discharge, in fulfilling a right, except in hudud and qisas, except in the capital punishments, because they're someone can go and pay on your behalf, right? So if it's established that you did $500 of damages on my behalf, against me, then you don't want to go to court because you don't want to be embarrassed. So you could send a wakil to go make the payment, right? But you cannot. But if Zubair stole and there's a had punishment against him, he can't send a substitute to be punished on his behalf, right? as is obvious. Like someone going to jail, you can't say, okay, well, I've found somebody. I hired I hired Brother Yaqub to go to jail instead of me. Right? You can't do that, right? في الحدود والقصاص and the like of them. فإن الوكالة لا تصح باستيفائها مع غيبة الموكل عن المجلس. Right? Because agency, being an agent in fulfilling, is not valid with respect to these if the person who appointed the agent is not present in the majlis. Right? وقال أبو حنيفة لا يجوز التوكيل بالخصومة إلا برضا الخصم. That إلا أن يكون الموكل مريضا أو غائبا مسيرة 3 أيام فصاعدا وقال يجوز التوكيل بغير رضا الخصم. And that's the fatwa. So he says that Abu Hanifa said that it is not permitted, i.e. not binding, to appoint an agent to represent you in a dispute unless the adversary, the other party, whether the claimant or the defendant, agrees, unless the one who appointed the agent has an excuse, such as sickness, or they're a traveling distance away, so it'd be difficult for them to come to represent themselves. Right? And this right, was chosen by the authors of the Mutun, but the Sahibain, Abu Hanifa's 2 main students, said no, it is permitted to appoint someone else to make the claim or make the defense on your behalf, even if the other party doesn't agree. Right? Right? And this was taken by the mutaakhirin. There's debate back and forth. There's 2 things. There's strength of evidence, right? And the other is practicality, right? Practicality. So most of the later scholars, right, said that the fatwa of the later scholars is on the position of the Sahibain, full stop, right? On this issue particularly. Then he said, ومن شرط الوكالة أن يكون الموكل ممن يملك التصرف. Right? وتلزمه الأحكام. From the conditions of validly appointing someone as your wakil, your agent, is that there be someone who has the right of transacting. So you can appoint a 2-year-old child to represent you, right? Or to buy on your behalf, right? And right? Or someone insane, for example. وأن والوكيل, right? So sorry, there's 2 things, right? The muwakkil, right? The muwakkil, the one appointing an agent, has to have the right of transacting, right? And the wakil, so the muwakkil, the one who appoints an agent, has to have the right of transacting. That's, why? So a child or someone insane could not appoint an agent, right? Because they could not transact themselves. So they can't appoint someone to transact on their behalf. Now, in the case of someone, there being a need to transact on their behalf, then that's where there'd be someone appointed to transact on their behalf, right? That's a separate issue, right? In the case of the sabi or the majnoon, right? والوكيل ممن يعقل العقد, and the one appointed the agent has to be someone who has the capacity to understand the transaction. So they have to ويقصده, right? And who could choose it, right? So what does this exclude? The child, the non-discerning child, or the insane person. So you can appoint a child to buy something on your behalf. So if someone sends a child to do the groceries, the child is acting as a wakil. So a discerning child can be appointed, right? And that's, like to do the groceries, for example, right? Right? So this is the principle. Then he says, وَإِذَا وَكَّلَ الْحُرُّ الْبَالِغُ أو المأذون مثلهما جاز وإن وكلا صبيا محجورا يعقل البيع والشراء أو عبدا محجورا جاز ولا تتعلق بهما الحقوق. Right? So if a free adult or or a slave who has the permission of transacting appoints the like of them, right? Either a free adult or one with a permission to transact, whether a slave with the permission of transacting or a child with the permission of transacting, appoints the like of them, it's valid and binding. And if they appoint a child who's been prevented from transacting, so let's say in the village there's this, because Sabi al-Mumayyiz can be prevented from transacting, right? So in the village, in the marketplace, Umar Basha has announced that my two sons, aged 8 and 10, don't have the right to buy and sell anything except for bread and milk. Right? Then that's mahjur. They're prevented from transacting. Right? So if someone appoints a child prevented from transaction, but they are of discerning age, right? So they understand buying and selling. Okay? So this is sin tamiz, or someone appoints a slave who's prevented from transacting. It is also valid. However, rights and responsibilities do not relate to them. وتتعلق بموكلهما. Okay? So if somebody appointed so let's say Umar Basha, his son, what's his son's name? Muhammad. So Muhammad ibn Umar Basha is Sabi Mahjur, is prevented from transaction. Right? So what happens? Uncle Hamza, knowing that Muhammad bin Umar is not allowed to transact, still appoints him as his agent. Then what happens? Muhammad bin Umar Basha is not responsible for delivery, for payment, etc. The responsibilities of the transaction would return to the one who appointed them. This is if they knew that the person is not allowed to transact. Right? There's a really nice summary of the conditions of agency in the commentary of Ali Haydar on the Majalla in volume 1, page 568 at Khulasat Shurut al-Wakala. Okay? And you can find it through the Shamila as well. Khulasat Shurut al-Wakala, the summary of the conditions of agency. والعقود التي يعقدها الوكلاء على ضربين. The transactions that are engaged in by an agent, by a wakil, are of two types. Right? فكل عقد يضيفه الوكيل إلى نفسه مثل البيع والإجارة فحقوق ذلك العقد تتعلق بالوكيل دون الموكل. So one kind of transaction, the first kind of transaction is every transaction that the agent initially يضيفه أي ابتداء, right? يضيفه ابتداء, that are initially ascribed or can be ascribed by the agent to himself, like a purchase or a hire, then the rights, the responsibilities of that transaction are initially related to the agent, not the person who appointed them. How? Let's say I asked Omar Basha to go and buy a Blue Yeti mic, right? The confusing thing is you have a black Blue Yeti mic. So I asked him to go buy the mic. Now, when he goes shopping and I gave him the money, does he have to say, I am not buying this on behalf of myself? No. When you go buy it, who do you ascribe it to? You ascribe it to yourself. So now once you bought it, you don't have to mention that I'm buying it on behalf of somebody else, right? You ascribe it to yourself. I'm buying this, but then you put the payment in, say, sorry, I'm not paying for it. Go ask Uncle Rabbani. Right? Would any seller accept that? No. Right? So the responsibilities of the transaction initially, until delivered, etc., go back to the agent there. Right? Such as what? So he tells us, فَيَسَلِّمُ الْمَبِيعَ. So the agent is the one who's responsible for delivering the item of sale. وَيَقْبِضُ الثَّمَنِ. And the agent is the one who collects the payment. Unless they agreed otherwise, right? Because you can make someone an agent just for payment or just for delivery, or but وَيُطَالِبِ الثَّمَنِ. And someone who's appointed to sell on your behalf, they can demand the payment, right? You can't say, so let's say I appointed Omar Basha to sell the Blue Yeti mic. So he sold it, but then Hamza, then Uncle Hamza says, I'm not going to pay you. I'm going to pay Sidi Faraz. No, he can't do that, because the transaction is ascribed to the agent here initially, right? ويطالب بالثمن إذا اشترى ويقبض المبيع, and they take possession of the item of sale. ويخاصم بالعيب, and it's the agent who can then dispute regarding the عيب, the blemish, if there's a blemish in it. But this is one type of transaction. Another type of transaction, you don't ascribe it to yourself, right? Because you can appoint someone as an agent to conduct your marriage. But imagine if Zubair goes and proposes to Zubaydah, I marry you for the mahar of $10,000. She agrees, and there's witnesses, and says, oh, by the way, I was not marrying you for myself. I was marrying you for Kamil. Would that be accepted? Of course not. That's the second type of contract, right? وَكُلُّ عَقْدٍ يُضِيفُهُ إِلَى مُوَكِّلِهِ كالنكاح والخلع والصلح من دم العمد فإن حقوقه تتعلق بالموكل. And every contract that the agent ascribes to the one they're an agent for, its rights go back to the one who appointed them, such as that these are things that you could not ascribe to the agent, such as what? Such as marriage. Right? Such as marriage. So they say that, if someone is conducting a nikah for another, and the agent says, I marry you, and they pause, and the woman says, and and the other party says, I accept, but they said, I marry you on behalf of so and so, right? Right. So that's why you have to be careful. Of course, there are ways to handle these things, right? But there are scenarios where, if the wakil is not careful, they could make the woman permanently unmarriageable to the person she's supposed to marry. Those are far-fetched cases, right? That's why one, and you should know what's the difference between nikahul banat and nikahul ummahat. Okay? That requires review. Okay. Bismillah. Kan nikah wal khula, right? Or when they agree to khula, right? To divest themselves of the marriage, right? And khula, of course, we've taken already. There's misperception that it has to be ala mal. It depends. If the woman is the party to whom the end of the marriage is ascribed, that she was the one not fulfilling rights, then then mahar can be the return of the mahar can be demanded. But if the husband was the negligent party, then his demanding the mahar would be impermissible and a major sin. Okay, Bismillah. وَالصُّلْحْ مِنْ دَمِ الْعَمْدِ, and if to come to a settlement on a deliberate death, then its rights return to the one who so someone was speeding and they killed someone, etc. Such things, they went and made the settlement, but the payment but it's ascribed to the person. They say, so I'm sorry I killed you. They didn't. Right? That is ascribed directly to the muwakkil, the one who appointed the agent, not to the wakil. Right? Then in that, because here the wakil would count as a safir. They're simply relating on behalf of the other party. Okay. فلا يطالب وكيل الزوج بالمهر. So the one who acted as an agent on behalf of the husband, right? The woman or her family cannot demand that the agent pay the mahar. Right? ويلزم وكيل المرأة تسليمها. And the person, they got married, and now the woman is not coming to join her husband. The wakil has nothing to do with that. Like, he can't be demanded. No, you have to go bring the woman, because he's in these contracts, and the most common being marriage and and khula, for example. This person is just a safir. They're almost like an ambassador. They're just relaying on behalf of another. Okay. وإذا طالب الموكل المشتري بالثمن فله أن يمنعه إياه. Okay. إذا طالب الموكل المشتري. Now, this is a new issue, right? Do you have it in a separate paragraph? Yeah, it should be, right? My copy has surreal paragraphing. Okay. If this is where one needs to وإذا طالب الموكل المشتري, right? المشترية, right? Right? If the agent demands, so from the buyer to pay the price, فله أي للمشتري, the buyer has the right to refuse. What's the scenario? I appointed Umar as agent to sell my mic to Uncle Hamza. Payable in a week's time. Right? So I am the muwakkil. I am the one who appointed the agent. Umar is the wakil. See, the Hamza is the mushtari, the buyer. Now, when a week comes, whom does Sidi Hamza, Uncle Hamza, have to pay? The agent, right? Because the agent's acting like, he's taken on this agency. The agency may even be for a payment, right? So there's rights related to you as well, because the agent may be voluntary, may be charging a commission for doing this, right? Like an employee, or like a, what do you call it? Like an agent, right? They're being paid to do these things they're hired to like a sales agent, for example. So you have rights related to this as well, right? And there's other reasons. The seller can refuse to pay to the muwakkil, right? فَإِنْ دَفَعَهُ إِلَيْهِ جَازَ. But if they pay it to them, it is valid, right? وَلَمْ يَكُنْ لِلْوَكِيلِ أَنْ يُطَالِبَهُ بِهِ ثَانِيًا. And in this scenario, the wakil, Umar, would not have the right to demand it a second time, right? And that's a scenario that in a sales agency contract should be agreed upon. In the event of direct payment, etc., what happens to commission, etc., right? Because that leads to dispute, right? How? Someone selling sibhas on behalf of another, right? So they're earning their commission from the money they collect. But then if you transfer the money directly to the sibha company, the agent made the sale, they may miss out on getting their commission, right? Their proper thing is to take those things into account. But also, as the buyer, you need to be sensitive to those kinds of scenarios, right? And this happens a lot, right? With informal sales and so on. Especially when you know both buyer and the agent, for example. Okay. ومن وكل رجلا بشراء شيء فلا بد من تسمية جنسه وصفته أو جنسه ومبلغ ثمنه إلا أن يوكله وكالة عامة فيقول ابتع لي ما رأيت. Because this is تفويض. This issue results in a lot of dispute, right? Whoever appoints an agent to buy something on their behalf, it is necessary, in order for this agency to be sound, that one mention the category and the quality, right? Or the category and the price, right? Right? They say بما تزول به الجهالة الفاحشة, right? That which lifts major dispute, right? عادة, right? إلا أن يوكله, unless one gives general agency by saying buy whatever you wish, right? And where does this get tricky? There's an akhlaqi there's a legal aspect and an akhlaqi aspect, right? The akhlaqi aspect, so the legal aspect is one needs to be careful. So for example, if you said buy me a pen, This is a problem. Why? Because pens go down from a simple, like Bic kind of pen. How much would those be? Like 10 for $1, let's say. Or whatever, 5 for... And you could have a better quality pen that's $20, right? So you could have a $1 pen, a $10 pen, a $20 pen, and you could have a $200 pen or whatever, right? They're all pens, right? So in this kind of situation, this would be a jahala, this would be fasid. Unless you said, buy me any pen. But that is problematic. It is valid, because then if the person bought you a $150 pen, you'd have to pay for it. Though there would be an argument that would be covered by that which is customarily bought for another person, right? Because then we'd apply urf, right? Right? So here, there's levels of non-definition. There's complete non-definition, slight non-definition, and gross non-definition. In agency, slight non-definition is excused, because agency is based on another person exercising their judgment on your behalf, right? But major non-definition is jahala fahisha, is not excused. And there's a really nice summary here in Jazakallah khair, in the Lubab, and you would do well to take notes on this section. In the Lubab, he has like a paragraph there, right? So it's best when you ask somebody, right, just practically, because we're not just learning for theory, but for practice, that if you appoint someone as an agent, you have to morally ask yourself the question, right? That, for example, if you wanted a particular edition, right? You wanted Mullah Ali al-Qari's commentary on the Burda. Right? Now, you don't know if you care about what edition you want. Then, because if you appoint someone as an agent, buy me a copy of that, then you made itlaq. You specified what you want. They got you a poor copy. You didn't specify, right? That gets tricky, right? So where you are particular, specify, right? Say, I want such and such. This is not necessarily a good edition. I want such and such edition, right? If you're particular, you have a right of specification. Then you don't find it, they asked you, right? If you do want to leave it open, it's best to leave it open. Buy me any copy you find, right? So in Wakala, to be specific, right? Either to define, whether in specification or in making it general. But also it's setting a price ceiling is also important. Setting a price ceiling is also important, because what if someone finds it very expensive, right? Right? So, right? So, for example, you wanted someone to buy you a tub of ice cream. And buy me a tub of chocolate ice cream. Okay, anything that they get that is within market price would be reasonable, right? If they got you a $250 tub of ice cream from some super ice cream, whatever, then that would be outside normal limits. But it can lead to dispute, right? Because a tub of ice cream from the supermarket, 2 liters, how much does it cost? $5. Let's say $5. But if you get a 2-liter tub from an ice cream parlor could be $20, right? Correct? Yeah, like, right? So it's best to put some kind of definition there to avoid these disputes, right? Because particularly where there is a degree of variance, and this always doesn't always, but it, jahala is something that one should anticipate, that if this non-definition could lead to dispute, then we take care of it before. إلا أن تكون تجارة عن تراض منكم, except that it be through trade on the basis of عن. Like, and what's the meaning of عن? Okay. Okay. Away from, like from, right? So it's the taradi comes first, then the transaction comes, right? So be careful about this. Like when you appoint somebody, and there's a lot of time non-definition on this, or and a good practice is where you can to make ta'keed. So, for example, we asked Uncle Hamza to order a whole bunch of books before placing the order, just to run it by. This is what I found. Are you okay with this? Yes. And you get it. Right? الصريح أقوى من الدلالة. The explicit is better than the indication. Right? So, where you can get إذن صريح, either you have specification or explicit approval, that is أولى وأحرى وأبعد من الشبهة. It's superior in all ways, right? And then people feel bad. I think I mentioned to you guys when I end up paying $300+, whatever, 17 years ago, for one book at a time when that was nearly my whole month's budget. And I've never read the book. Astaghfirullah. Allahumma salli. I've looked at it. Okay. Al-Jamal al-Hamziyya. It got me interested in the Hamziyya. I read other things on the Hamziyya, but not that one. Ironically. Bismillah. وإذا اشترى الوكيل وقبض المبيع ثم اطلع على عيب فله للوكيل أن يرده بالعيب ما دام المبيع في يده. Right? Now this is a separate issue. If the agent, the wakil, buys and takes possession of the item that they purchased, and then they find a defect in it, the agent has the right to refund it for that defect, as long as they still have the item purchased in their possession. فإن سلمه للموكل, if they then return it, if they then deliver it to the person who appointed them as an agent, لم يرده, then they don't have the right of refunding it, إلا بإذنه, except with the permission of the person who appointed them, right? So I asked Umar to buy a copy of Zubda Sharh al-Burda. So he got me a copy, this particular one, right? Right? And then he saw, oh my goodness, there's a aib in it, right? There's a blank page. But before returning it, what did he do? He gave it to me. So I have it now. You can't take it from my possession because your agency is done to return it, except with my permission. Why? Because I might say, you know what? The blank page is in the indexes. I don't care. I'm fine with it now. Right? You've done your job. Right? وكيف ترى ليلى بعين بها ترى بها سواها وما طهرتها بالمدامع. Mullah al-Qari quotes, how can you behold Layla with eyes by which you see other than her, and you haven't purified them with tears? Okay, Bismillah. Okay. ويجوز التوكيل بعقد الصرف والسلم. It is valid to appoint as another as an agent on your behalf with both عقد الصرف, صرف exchange contracts, and salam. And the issue why this is mentioned is that in both qabd is required, right? As you can review the 2 chapters, we can review all the fiqh, right? But in sarf, there has to be qabd al-iwadain qabl al-iftiraq min al-majlis. One has to take possession of the 2 items of exchange in the sarf exchange, and we discussed what about modern monetary transactions and so on. فإن فارق الوكيل صاحبه قبل القبض بطل العقد. And there, the sarf and salam contracts of the wakil are ascribed to him, to them. So if the wakil, the agent, parts from the other transacting party before taking possession, then the contract is invalidated. ولا يعتبر مفارقة الموكل. But the leaving of the appointing party does not count, right? In these. وإذا دفع الوكيل بالشراء الثمن من ماله وقبض المبيع فله أن يرجع به على الموكل. So if the agent who's appointed to buy something pays for the item from their own property, and this is even without explicit permission from the agent, and once they have taken possession of the item of sale, they have a right. فَلَهُ يَحِقْ لَهُ. They have the right to demand payment from the person who appointed them agent. Because the permission is there by indication, right? What's the scenario? I asked Uncle Hamza to buy me a copy of the Sharh al-Burda, right? And I specified the edition. I didn't give him the money. Now, so the explicit, the ibara of the tawkil, the expression of the tawkil was, buy such and such, and we'd specified it sufficiently, right? I didn't give you the money for it. But if you buy it, what does buying something entail? That he'd have to pay for it. Right? I said, no, because if I want to say buy it but don't pay for it, rather make it due in installment, in a deferred payment later, then I could have specified that, right? That I want to buy it now and pay for it 6 months from now. That, because the basis of payment is now. So I didn't say anything like that, right? And I didn't give you the money. Didn't give Uncle Hamza the money. So in this situation, what happens? The wakil, the agent, paid for it. There's an idhn dilalatan, because buying something requires paying for it. If you didn't give the money, it's understood that they'd have to pay for it, and then I have the duty to pay for it without delay. Matlul ghaniyi dhulm. The delay in repayment of one able to is wrongdoing. And of course, when you appoint an agent, there's a moral duty to ensure that you have the capacity to fulfill on your behalf what the agent is doing for you. You ask someone to buy 10 things for you. They come back from overseas and say, okay, I got these things, can you pay? And then you say, oh, I'll need to pay you in 3 months. And that's zulm. That's injustice. Now, the tawkeel is an amana, right? And the wakil is ameen. Appointing someone as an agency is a trust, but the implications of trusts apply. So the item, the money or the item purchased is an amana in the hands of the agent. So he says, فَإِنْ هَلَكَ الْمَبِيعَ فِي يَدِهِ يَدِ الْوَكِيلِ قبل حبسه هلك من مال الموكل ولم يسقط الثمن. Right? If the item purchased perishes in the hands of the agent, it says قبل حبسه, before it's considered to have been withheld. Habs is withholding. Before it was withheld, it perishes from the hand. It perishes from the property of the one who appointed the agent. So the agent is not liable for it. I asked Uncle Zain to buy 2 fountain pens for me, and I'd specified the type and the color and everything, right? Proper. So he got them. Right? And before delivering them, something happened. Right? Something happened. He was walking down the street and a car rammed into him, and he wasn't hurt, but but the 2 fountain pens were destroyed. I still have to pay him for them. Why? Because it's an amana. It's an amana, and when he took qabd of them, he fulfilled it. I own, it entered my ownership, right? Even before qabd. Okay. And I have to pay the price. Because the principle is لأن يده كيد الموكل, right? لأن يد الوكيل كيد الموكل, because the hand of the agent is like the hand of the person who appointed them. This is, of course, in particular ways, right? من حيث الملك, right? مثلا, right? In some ways, not all. Okay. وله أن يحبسه when would someone withhold delivering it? له أن يحبسه حتى يستوفي الثمن. Right? One has the right to withhold it until they get the price for it. فإن حبسه, but if they withheld it, there's a risk. فهلك, and then it perished. كان مضمونا ضمان الرهن عند أبي حنيفة. Then one is liable for it with the liability due for a rahan according to عند أبي يوسف, according to Abu Yusuf. And the ضمان of the rahan is أقل من القيمة ومن الثمن, which is you have to pay for the lesser of the qima, the market value, and the price. This according to Abu Yusuf. And one has to compensate for it. Daman of the mabiya, of the selling price, according to Muhammad, and that's also the position of Abu Hanifa. And most of the scholars took this second position, right? One, because the position of Abu Hanifa, and because of the proof, right? Right. Now, what if you appointed 2 agents? How would you appoint 2 agents? This is a tricky thing to do, right? Say, okay, Hamza and Zain. I said I want the 2 of you to buy me a copy of Mulla Ali al-Qari's Ayn al-Ilm wa Zain al-Hilm. Right? I want both of you to buy it for me. 1 copy. I appointed 2 agents. Why would I appoint 2 agents? I want 2 people's opinion, for example, right? So this is the next issue, right? Like, for example, for a house, I want to buy a house. I don't want to buy a house. Zubair wants to buy a house, but he's lazy. He doesn't want to go house shopping, so he appoints 2 people that if both of you agree, right? That's the implication, right? So إذا وكل رجلين فليس لأحدهما يتصرف فيما وكل فيه دون الآخر. If one appoints 2 people as agents for one thing, right, and it's specified, then neither one can transact in it without the in that matter without the other, right? And this would apply to things that require judgment, such as buying, etc., right? And there's إلا أن يوكلهما بالخصومة, right? Unless one appoints them to be one's, to make one's case against another, because only one person is sufficient for that, right? And also because in court you can't appoint 2 people as agents to make your case, because they may make contrary case, right? أو بطلاق زوجته, or والعياذ بالله, if you appoint 2 people that both of you have to divorce her. No, because divorce is something that لا يتجزأ. It either happens or it doesn't, and if pronounced, it counts. Right? بغير عوض, without compensation. أو بعتق عبده, or to free a slave. بغير عوض, without payment, because if there's payment involved, then you could see where they have to agree that yes, she wants divorce. So okay, I'll divorce you if you agree to pay a reasonable settlement. أو برد وديعة عنده, or to take back an item in safekeeping, right? Because it doesn't need judgment, right? I gave my copy of Sharh al-Burda to Sidi Yaqub. I appoint 2 people to go pick it up from him. But do both of them have to agree to pick it up? No. لا يرجع إلى الرأي. It's not a matter that returns to judgment. If either one picks it up, it's sufficient, right? أو بقضاء دين عليه, or to fulfill a debt. The fulfillment of the debt, it's sufficient that the payment be made. I owe Sidi Yaqub $25. I asked 2 people to discharge it. It's not a matter that returns to opinion. If either of them makes the payment, I owe them the money, right? So there's a lot of issues related to wakala. So we will continue here, right? He says, rahimahullah, وَلَيْسَ لِلْوَكِيلِ أَنْ يُوَكِّلَ فِيمَا وُكِّلَ بِهِ. The agent does not have the right to appoint another agent in what they're made an agent for. إِلَّا أَنْ يَأْذَنَ الْمُوَكِّلِ, unless the one who appointed them as an agent gives permission, right? أو يقول له اعمل برأيك, or say, do as you wish. And this is also something, because agency is wakala. right? And this is something where it gets tricky, right? So for example, and you have to be careful with companies, right? So for example, Uncle Hamza decides to start a bookselling company, right? So and that's why agency is really important, right? I trust Uncle Hamza's judgment in good editions of books. But I'm not talking about any of our Hamzas, right? At least not yet. Right? يعني الوصف العارض لابد من إثباته, right? So let's say I trust Uncle Hamza's judgment in books. So I appoint him as an agent, said, buy me a good copy of Hashit ibn Abidin. I trust his judgment. Now he goes and asks Omar Basha. I didn't want Omar Basha to make the sale. So to make the choice, right? Unless there's idhn, unless there's permission, right? So one needs to be careful, right? Like if I'm dealing with Ustad Mahmoud al-Beiruti, there's a difference. If I want him to seek, then I should, it's safer to specify. Akhlaqiyan, let's say I want your judgment, as opposed to, am I dealing with him as an individual or am I dealing with Maktabatul Beiruti, right? So with people, it gets tricky. I have a friend who owns a book publishing company. Once I asked him to get a series of books, he appointed, I said, I want just only the best editions. He gave it to his employee. His employee got all kinds of disastrous editions. And it was shipped. He said, Alhamdulillah, Sidi, I shipped it in a very timely fashion. But they're disastrous books. So they're, and of course, I didn't have a right of objection, because the basis, if someone does a business, right, that they're acting on, in the context of their business. But so it does get tricky with companies, right? And if you're dealing with the owner of the company, for example, right? Then are you dealing with the individual as individual, or dealing with them as part of a company? Because the company, if you're dealing with the company, then any employee of the company could do it, right? ويقول اعمل برأيك, right? Say, act with your judgment. فإن وكل بغير إذن موكله فعقد وكيله بحضرته جاز، وإن عقد بغير حضرته فأجازه الوكيل الأول جاز. Right? If the agent appointed another as to transact without permission of the one who appointed them, and the second agent acted in the presence of the first agent, this is valid because their opinion is implicitly present. Or if they transacted not in their presence, but the first agent approved it, right? Because they say الإجازة اللاحقة بمنزلة الإذن السابق. Right? There's a principle here, right? They say الإجازة اللاحقة, right? الإجازة اللاحقة بمنزلة الإذن السابق. A later approval generally counts like a prior permission. So I asked Uncle Hamza that I want these 10 books and I want you to choose them. He didn't actually go and choose them himself. Right? He appointed someone to go make the choices, then he approved it. But of course, the diyana part remains, which is what? The amana, that if I made specifications, you're responsible to be honest about them, right? That if it's not something you would have chosen and I'm relying on your judgment, then minimally you're responsible to ensuring that the terms of our agency are fulfilled. And in terms of istihbab, that you have to ask yourself the honest question, right? That what is in the interest of the person? That's nusх. In nasiha there, the basic is that you're fulfilling the terms of the agency as entrusted. The recommended is that the wakil take into account not just the right of the haqq of the muwakkil, but their nusх, talabul khair fi haqq al-ghayr, that you seek the good, that this is ma'roof, right? This is ma'roof, right? It's like my good friend Shaykh Iyad al-Ghawj, several times I've asked him for some books, etc. He said, let's see, wait 3 months because there's a better edition that's coming. راح يعجبك. You will be impressed by it. I said, but 3 months I'm not here. He said, انتظر. I said, wait. Right? That's, that is the better way, right? Now then he tells us للموكل أن يعزل الوكيل عن الوكالة, right? The one who appoints an agent has the right to remove the agent from their agency, right? I asked, so for example, a few people have asked me, and I have an update about that, to buy them copies, to order copies of Hashit bin Abdin. So I have an update about pricing is actually cheaper than we anticipated. So let's say before I transact, right? So Uncle Zain appointed me as an agent on his behalf to get the Bulaq edition of Hashit ibn Abdin. I'm his agent. Before I initiate the transaction, he has the right to remove me. Then I no longer have the right of transacting on his behalf. I'd be considered fuduli, one transacting without permission. But what if he appointed me as an agent and then decided that he no longer wanted me to be agent, but didn't inform me, and I transacted? He tells us, فَإِن لَمْ يَبْلُغْهُ الْعَزْلُ فَهُوَ عَلَى وَكَالَتِهِ. If the news of the removal of the agent did not reach the agent, one remains with one's right of agency. وَتَصَرُّفُهُ جَائِزٌ حَتَّى يَعْلَمْ. And their transaction is valid and binding upon the muwakkil, upon the one who appointed them, until they come to know through reasonable means, right? Now, wakala is based on judgment, right? So it is not transferred upon death, right? وَتَبْطُلُ الْوَكَالَةِ بِمَوْتِ الْمُوَكِّلِ وَجُنُونِهِ جُنُونًا مُطْبِقًا. Agency is invalidated by the death of the agent and by them entering into prolonged insanity, right? وَلَحَاقِهِ بِدَارِ الْكُفْرِ. And if they disappear in non-Muslim lands, right? And this is in the old days, where if someone moved to non-Muslim land, you won't be able to contact them customarily. مرتدا, especially if they apostatize, right? وكذا إن إذا وكل المكاتب ثم عجز. Likewise, if you appointed a mukatab slave to transact, to be your agent, but then they lost their status as a mukatab. أو المأذون. Likewise, with a slave who had the right of transaction, and then that was withdrawn, the agency is lifted. فحجر عليه, and then they're prevented from transaction. أو الشريكان, and agency is also lifted if two people were partners, so each is acting as an agent on the behalf of the other. فافترقا, and then they annulled their partnership. فهذه الوجوه تبطل الوكالة. In all these ways, the contract of agency is annulled. علم الوكيل أو لم يعلم, whether the wakil knows or doesn't. Okay. And there's a few useful points in the commentary here. One is that Junun al-Mutbiq, the fatwa is that it's a month, right? that's useful, now, after Quhustani in your copy, what do you have? Al-Quhustani wal? Could you check that? Not right now, because many copies of the Lubab mention ومثله في القهستاني والباقلاني. It should be الباقاني, who is شارح المجمع والملتقى. Right? So just note, if you're following, anyone have al-Baqani of those who are following the class? You have al-Baqani. Allah يرضى عنك. Yes. وهو كذلك. It's al-Baqani, not al-Baqillani. Al-Baqillani, one of the great imams of ilm al-kalam, but he has nothing to do with the Hanafi madhab. He's Maliki, I believe. Right? And for that to be in multiple editions is spectacularly bad. Right? It's al-Baqani, and he's Sharih al-Majma' wal-Multaqa. We could check it in the Makhtut as well. Okay, Bismillah. Okay. وإذا مات الوكيل أو جن جنونا مطبقا بطلت وكالته. If the person who appointed the agent, right? إذا مات الوكيل. إذا مات الوكيل. So this is if the one who appointed the wakil, these things happen, the wakala is done. If the muwakkil, the one who appointed the agent, they die, the wakala is invalidated. Likewise, if the agent dies, or أو جن جنونا مطبقا بطلت وكالته. Likewise, the wakala is annulled. وإن لحق بدار الحرب مرتدا لم يجوز له التصرف. And if they apostatized والعياذ بالله and moved and disappeared in Dar al-Harb, then it's not permitted for them to transact, because then they lose the fitness of transaction. إلا أن يعود مسلما, unless they come back as a Muslim within reasonable period, and they differed on the period. Right? Now, and then there are derivative rulings related to wakala. We'll stop there, bi'idhnillahi ta'ala, because we've covered quite a bit. And we'll take the rest next class. Wakala, and we'll begin kafala as well, bi'idhnillahi ta'ala. So be prepared for kafala as well. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين.
Can a wakil appoint another wakil without the permission of the muwakkil in those transactions which don't return to judgment, like paying a debt, freeing a slave without price, etc., without needing to be present for the transaction or approving?
Yeah. Where that would be customarily accepted, right? Because there are scenarios where that might not be customarily accepted. Like, for example, I gave the money to Uncle Hamza, but Uncle Hamza is a tough guy, right? And the payment's in a dangerous neighborhood, so he appoints some small little guy to go into a rough neighborhood. The guy is trustworthy, but I wouldn't be. I'm satisfied. Uncle Hamza is a tough dude, but this other guy, I wouldn't be. So in that which is customarily accepted. والله سبحانه وتعالى أعلم وحسبنا ونعم الوكيل وصلى الله على سيدنا محمد وآله وحزبه والحمد لله رب العالمين.